I want to talk about the idea of selling or transitioning from a practice. In the legal profession, this is not as straightforward as it is in some others. As Sam indicated at the beginning, we have a coaching company, but we also have a brokerage. And the brokerage firm that we bought 3 years ago was a firm that was actually started in 2002, Henderson, the Henderson Business Group. And we did a lot of joint work together or strategic partnership work because we would coach a client. The way we first met, as a matter of fact, was we were coaching a client who did a startup making what he called virgin body care products, which are lotions and lip balms and so forth that are organic and without harmful chemicals and so forth. And he started with his fiancée in the kitchen using a turkey baster to fill lip balm tubes and hand labeling, right? And this eventually turned into a little factory with about 8 or 10 employees, and it was really cranking out the product with what began with used machines that would fill the product and mix the product and label the product and so on. And he came to me after about 1.5 years and said he wanted to sell his business. And I said, really? He was just turning 30, and I said, why would you want to sell so soon? Because you're really getting this thing off the ground. And he said, well, I want to climb Mount Everest, and I'm afraid I'll get too old. So I want to cash in and go climb Mount Everest, and then I'll do something else. And I said, well, great. That's one of the best excuses I've ever heard. And so he showed me the numbers, and at the time I looked at him, and he told me what he wanted to get for the business, and frankly, it was what he wanted was almost half of what it was worth. Not more than what it was worth, but half. And when I told him what I thought he could get for it, he was quite surprised. It was well into 7 figures. And he said, I'm running with a guy over in Cedar Rapids who says he's in the brokerage business. His name happened to be Dennis Henderson. And he said, I think I'll get a second opinion. I said, that's a wonderful idea. You should. So he went, and Denny, this was the son of the Dennis I'm partners with now, gave him an opinion that was only $10,000 different than mine. It was really close. And so that made a believer out of him. He sold the company within 3 months, and he had 4 full-price offers. And he not only got what he was asking for, he got a piece of the next 5 years' growth. That company today is still in existence in Cedar Rapids. It's called Raining Rose. They just received an entrepreneurship award and built a 60,000 square foot facility. So they've grown the business, the buyers have. Well, that's how we met Henderson, and we started sharing clients. In other words, they would run into a business that they would talk about, listing for sale, and the business owner was disappointed at the price, so we would end up coaching them for a while until we could help drive the price up, and vice versa. We'd have clients that were ready to sell, and we'd send them to the Henderson Group. So about 3 years ago, we bought the business, and we incorporated it into ours. So I've been in the brokerage business for the last at least 3 years. Probably longer than that. I think all of you have at one time or another been involved in some kind of brokerage activity, right, in connection with a business. You almost feel like you're in mergers and acquisitions. If you're in business, you're giving advice on that at times. So let's talk about law practices in particular. I'm going to give you some of the experience of other businesses at the same time so that you get the context of what we're looking at when we talk about a business of value and how to value a business, but also I want to talk about the restrictions there are on lawyers selling practices. Best time to plant a tree is 20 years ago, of course. So if you wanted to start building your business for sale, you should have started it the day you opened the practice, right? That's the best time to start. Second best time is right now to do something if you're going to. So, what limits the value of a business? Well, flat or declining revenues or profits. If you've got a practice that's just falling in revenue every year because you're slowing down and you're not, doing anything more than you have to, and you're trying to wind down and so forth, it's going to reflect in what anybody's willing to pay for it. I mean, they're going to see it as a practice that's going away. The market share is declining or flat. So you could have a business that's actually sustaining its revenue, but the rest of the market's eating you alive because more lawyers have moved in and the market is declining and so on, and you just happen to be hanging on to the same clients. Dependence on the owner or certain key people. The whole first part of the morning, we talked about this. If it's totally dependent on you, what are you selling, right? So it's that conversation. Key people are nearing retirement and there's no replacements. The buyer needs to know the product or service. Well, obviously, in the case of law, they have to. They have to be lawyers, so that's an obvious one. But in the general business world, you could theoretically sell a business where the buyer knows absolutely not one thing about the widget it makes. And they could run a very successful business. They could probably eat the lunch of the widget maker who runs a similar business. Because that person is paying attention to the business of making widgets, which is very different, right? No clear systems. People own the knowledge. Finances are not clear and justifiable. Somewhere earlier we were talking about restaurants. Can't tell you how many times I hear a restaurant owner saying, well, it really makes more than this. I mean, everybody, wink, wink, everybody, it's like, well, I'm sorry, we're only going to show tax returns. You can't get it twice, So if you're willing to lie to one of the most powerful agencies in the U.S. government, the buyer might think, well, maybe you're willing to fudge a little to them too. So, heavy dependence on very few customers or clients. Most businesses repeat business with very few new clients. One of the common questions we ask with a new client is, what's the percentage of new business you get every year? A healthy percentage is between 15 and 20% of their total revenue. There are businesses with almost no new business every year, and you got to question how long have these clients been around, what's their volatility, and so forth. The business is a commodity in the eyes of the public. Now, most law firms, in smaller communities especially, and even in larger communities, are far more branded in the sense that their clients know who they are. They're very identifiable to their clients. And so there is a very close relationship between the client and the lawyer, and so this doesn't become as much of an issue. But when you're attracting new clients to a particular field of law that you're trying to promote, that you want to be able to practice more of and so forth, you've got to figure out how to become a little bit more of a commodity and more of a brand, if you will, for that particular type. So the opposite is true. Revenues and profits are increasing every year. Market share is a positive trend. Systems run the business. People run the systems. There is a succession plan in place for key people. You already know how you're going to replace people and what that process is going to look like. The business itself owns its own intelligence. The finances are well documented. Now earlier, when we talk about the business owning its own intelligence, a lot of what we're talking about here, in your case, are related to the two questions that were asked at the end of the last session. How do we bottle what people need to do in our practice to get it done, so that we're not reliant on that person's and their whims and their wishes and their mood? How do we make sure that we get stuff done and we own the intelligence of that? And a lot of that is just simply process. A lot of that is admin. A lot of that is making things flow within the business, billing and all of that kind of stuff that has to happen. And it has to be hopefully a well-documented system and a system that's current. There's a broad base of clients. That increases its value. That increases its viability as a business. There's a strong percentage of new clients each year, and the business is well differentiated with its clients. In other words, they come to you for a reason. They know why they're coming to you. They understand why they're coming to you. Now, that's a hard one for all of us, and I talked about that in the marketing thing. I mean, we are all legends in our own mind, obviously, and we all believe that we're different. We all believe that people ought to talk to us because we do it better than anybody else, but that's not how the public sees it all the time. The public sees going to a lawyer as, well, a lawyer is a lawyer is a lawyer, and I get questions like that all the time since I don't practice full-time anymore. Can you recommend somebody, right? Constantly getting that question, and 'cause they don't know. and they don't know how to find one even. So how do you continue to differentiate yourself? So, is it time to sell or retire? Where are you in the life cycle of your business? Are you at the top of your game? I mean, have you gone over the top of your game, or are you still there? Are you willing to invest the resources to keep up with changing laws and technology? Are you willing to continue to grow? Are you willing to continue to spend money where needed in order to keep up with technology, in order to keep up with your education, keep up with your knowledge and training, and all of the things that go into staying current? Or are you bored? Now, I have to honestly say, 15 years ago, I was getting a little bored. I was thinking, there's got to be another way to do this. The law practice has been wonderful to me. It's been great to me, but there's got to be something else that I can do. And I just happened to come upon something that attracted my attention. It was like a shiny object. And, so you got to ask yourself that question honestly. Do challenges and changes make you feel tired and not excited? Do you want a change in lifestyle? And do you have a plan for life after the practice? That's a big question. The first thing I ask anybody of any business that comes in and says, I want to sell my business, my first question is, what are you going to do afterwards? I can't tell you the number of times that brokers have gotten to the closing table and the seller says, I'm not selling. I don't know what I'm going to do. I have no idea what I'm going to do. I've done this for 30 years, and, that's it. So let's have that conversation day one. That's a better time to have that conversation. Am I planning to die with my boots on? So, are you just planning on going and going and going until it's done and so on? The partner I talked about, when I had the firm, I got a call from an older lawyer in Watchir named Carl Dreigert, fine old man, and he was just a gentleman, absolute gentleman. Clients loved him. He was the pillar of the town and contributed constantly to everything going on there. Of course, it's a very small community. His main concern was what was going to happen to his clients, how they were going to get taken care of, and he felt that that such a family relationship with his clients that was his big concern. He didn't want to quit. He didn't want to stop, but he also knew that he was getting up there in age, and he was mentally getting up there, and I can't tell you how humbling it is to have a guy like Carl come into your office and show you a simple real estate contract and ask you to look it over to make sure that he didn't do anything wrong on it, that he didn't forget something. That's an extremely humbling experience, but I understand. He was worried that he would make a mistake at a certain point because he kept forgetting, and so we just took care of Carl. And that was the name of the game, and it was trying to make sure that all these clients were transitioning and so forth, and still had a lot of them. Most of his clients, of course, were dying off. Carl outlived most of his clients. That's the definition of a good probate lawyer. But he made it to 92, and the last conversation I had with him, they flew him in a helicopter to Iowa City, and I talked to him on the phone. That was the last conversation. He died in the hospital, and I said, Carl, how was the helicopter ride? And he said, I like the one in the Grand Canyon better. So key considerations. First of all is confidentiality. That's just absolutely critical. Now, that has a far more expanded meaning for lawyers than it does for anybody else. In the average business situation, what the average business owner is worried about and concerned about is the confidentiality as to their employees knowing that they're thinking about selling. That's a bad idea in most cases. Or their competitors. Can you imagine their competitors picking up the phone and say, hey, Joe's selling out. You're not going to have a permanent supplier anymore with Joe. Joe's gone. Why don't you, come over? We're going to be in business a long time. And they just start raiding the place, right? So there has to be a serious amount of effort given to confidentiality. Well, when it comes to law firms, the confidentiality twist is slightly different. Usually, in the case of law firms selling out, the staff is not quite unaware of it. They usually are fairly aware that there's going to be some kind of transition going on, and there has to be, as I'm going to describe under the rules, there has to be consideration given to the client's wishes, so there has to be notice given to the client and so forth. So the real thing is the client's information has to be treated with great confidence. There's only so much that you can tell an incoming buying attorney who's going to buy your practice before the deal actually is struck and before the clients are actually notified, and then they learn more afterwards, and what they've got to do afterwards, of course, is abide by whatever you agreed to with the client that you were going to do. In other words, they're inheriting your promises, right? And so it's a tricky transition that happens to protect the client while trying to make sure that this smooth transition takes place. So there are rules of professional conduct, which we're going to talk about in a minute. Pricing is really tricky, and I'll give you the reason why it's really tricky here. You know, as you know, most practices don't leave anything in at the end of the year for the most part. Everything that's left at the end, they take. So pricing it on a net profit basis or on a cash flow basis or on an income basis is very tricky. You have to actually create some artificial mathematics in order to make it happen, which the buyer would fully understand, but it's not the typical sale based on return on investment like you would with a manufacturing firm or with any other kind of company that maintains some kind of net profitability within their tax structure. Marketing, in all cases, goes back to the confidentiality issue. It's how do you let people know that this practice or this business is for sale without the competitors knowing about it exactly or without the employees knowing about it exactly, but getting enough legs on notifying the marketplace that there's something out there for sale. So you have blind sort of notices like you've seen in the Bar Journal and the Bar Magazine and so forth, practice for sale, where you go to a box number to respond to it and so forth. But we do the same thing in brokerage. What you see online when you go on our Henderson site are blind listings. A blind listing doesn't say the name of the business. It doesn't say what town it's in. It might say it's rural. It might say it's Midwest. It'll say it's a law practice, or it'll say it's a trucking company or something like that. And then it'll give numbers. It'll give 3 years worth of gross revenue, 3 years worth of seller discretionary earning amounts, and asking price. And somebody'd have to play 20 questions to figure out, what exact business that is, but they can see, well, that's about the right size, that's the kind of business I'm interested in. So then they contact us, and we get a confidentiality agreement signed. And we get the buyer to show us that they have money. Because if they don't have money, they are what we call a tire kicker, right? They can't do it. So why show them anything? They're a waste of time. So we pre-qualify that buyer before they get to see the real information. And the real information is a summary book. It's like a disclosure document that has copies of tax returns and various things like that. When you get to a law practice, there's certain kinds of information that you can only show numerically. You cannot show, lists of client names and things like that. That has to be disclosed on a very discrete basis with a special confidentiality agreement. Then there's financing. Typically, most businesses, when they sell, if there's a lot of blue sky, they're going to be financed by a bank with an SBA guarantee on it. Or if the buyer has enough personal collateral, they can probably get conventional financing. But typically, unless there's a lot of assets in the business, it's a blue sky sale. Law firms are almost all, if they're sold for anything over basic tangible assets, which the rules don't care about, you can go sell all the tangible assets you want and not worry about the rules. It's when you're selling goodwill and blue sky that they care. And that is what it is. It's blue sky. And typically that's going to be seller financed for the most part. You could get a bank loan. You could get an SBA loan. It depends on the size of the deal. But usually it becomes seller financed where you're getting paid by the buyer over a period of 2 or 3 years or whatever it is. And then there's deal structure to consider. We'll talk about that a little bit. There's taxation. And when I talk about taxation, the thing that we continually tell our clients is don't worry about what the sale price is. Worry about the walking away money. How much are you going to end up with in your pocket after you pay your taxes and after you pay our brokerage fee? Because depending on how the deal is structured, the sale price could be one or the other, and you could end up with the same money, depending on the structure of the deal. So it's really what we call the walking away money that you need to worry about. And then doing your homework. There is a tremendous amount of due diligence that is done when considering selling or buying a business. There is no less in a law firm and probably more questions asked about lots and lots of things, both on the buyer side and on the seller side. And I'm going to give you a list of some of those and you have them on the handout. So how does the general process work? I mean, when we're selling the average business, here's the process. And this is good for you to know, just representing business clients. If somebody decides they want to sell, this is how this works. First, there's an evaluation. We start off in every case saying, what would we say this is worth if we put it up for sale? And we listed it on the open market. What do we think we could get for you? And we do a number of calculations, and we show you how we did those calculations. This is very transparent. There's no secret behind any of this. It's generally done on a cash flow or a net cash flow basis, some multiple of that. So there's a business evaluation. Then there's marketing and advertising. So assuming you agree with the price and you list it, there's marketing and advertising. And I said that's done on a confidential basis. What we put out there hits over 150 websites in a second. We have our own website, plus we have internal industry subscriptions. We belong to M&A groups, and we belong to organizations that are brokerage organizations. So it'll be out there all over the place. We got an inquiry on an Iowa plastics company the other day from somebody in Mexico. So it hits every place. And then we do direct, solicitations. We have like 3,000 buyers at any given time that have said, I'm interested in a business. Show me whatever comes in, and we just automatically email them and show them what came out. In this case, though, if you're talking about a law firm, you would only go after lawyers. I mean, they're the only people that can buy a law firm, obviously. Then we qualify the buyers, as I talked about, make sure the tire kickers don't get through the door, make sure that they sign confidentiality agreements and so forth. And then, if it's appropriate and they're interested, there's a tour. They get to meet the seller, and usually the first meeting is off premises. It's not in the seller's office. It's usually in our office or someplace neutral. And then at some point, they're going to want to see the office. And if the employees are not in on the scoop, it's usually an evening meeting or a weekend meeting so that nobody's around to know what the meeting's about. And then there's an offer and acceptance. If it progresses to that stage, the buyer generally starts out making an offer, and that, as you know, as you have experienced, I'm sure, before, that goes back and forth 4, 5, 6 times before you arrive at the terms that you're willing to accept. And we make our offers solid, or they're firm offers, but they are subject to review by counsel for each of the parties and by their accountants. And those offers then, after the financing conversation happens, end up in definitive agreements that are prepared by counsel for the parties and accountants. So we get the parties, lawyers involved ASAP at that stage, as well as their accountants to comment on the tax ramifications of the sale and so forth. And financing, unlike a lot of other brokerage firms, I'd say most other brokerage firms, we don't quit when the offer and acceptance has come about, because does anybody have a guess? I don't think I left this slide on there. If I did, I apologize. But does anybody have a guess? Once an offer has been made and accepted, and there's now a binding offer and acceptance that's going to be, go to financing and get ready for closing. Nationally, do you know what the closing percentage is? Sam, don't answer this question because I think you know. Okay. Anybody?
35%.
12%. 12% actually make it to the closing table, okay? You know what the 10-year history is for the Henderson group? Now, this is my shameless pitch, okay? It's 89%. Why? 3 reasons. Proper evaluation, buyer vetting, right? Find the right buyers, the ones that are most qualified, and then we walk the financing all the way through the bank. We insist on preparing the bank financing documents and I don't mean the loan documents themselves, but the proposal, the tax returns and all of that goes into a book, and the buyer will say, well, I've had a 25-year experience with my bank. I'll just take it to them. And we'll say, please, let us put the book together. And please, let us walk into your bank with you, and we'll also walk into 4 other banks at the same time, because in our experience, please, understand this, Mr. Buyer, 50% of the time, your 25-year experience is just about to go up in smoke because your banker's not interested in financing this deal. They just don't have an appetite for this deal. We don't know that in advance, but it happens, and it happens often. So don't be disappointed, And so we ask to walk them through it. And there's always a bank interested. And we kind of keep track of that. I mean, we're a company that sells businesses, so we have bankers walking in our door all the time going, pick us. We have money to loan, pick us. What are you interested in these days? Well, we don't want trucks. We hate restaurants, and they'll tell us. And so we keep lists of what they're interested in. And do you have an appetite for this? What are your loan covered, debt covered service ratios, which is the ratio of cash flow that has to be there over and above what it costs to pay the debt as a cushion. So those ratios will be anywhere from 15 to 40, 0.15 to 0.4. So like you either got to have 115% or 140% of what you need to make the debt service payments as a cushion. So it depends on the bank, and it depends on the mood they're in at the time, and they change. So that's why if you just simply leave it up to the devices of the buyer and seller now that they've entered into their offer and acceptance, okay, go get financing. Let's get this ready for closing, and we'll depend on the banker to put the closing documents together. Ain't going to happen, except 12% of the time. That's when it'll happen. So then it closes. So I handed out a copy of the Rules of Professional Conduct, 17.1. For many, many years, as some of you probably know, it was not ethical under American bar standards, for example, to sell goodwill from a law practice. It said law practices have no goodwill, that the goodwill that exists in a law practice is completely attached to the lawyer themselves who would be departing the practice, so how could there be goodwill, right? That was the idea, that was the theory. And most larger practices, the bigger firms, you never really run into the sale issue because they keep bringing on new partners and younger partners, and they keep, and they have buyout agreements within the firm, which is different than selling the practice. That's not the same thing. So they have buy and sell arrangements, and they have retirement arrangements, and they have, deferred comp arrangements and various things like that get the older partners transitioned out, and the younger partners take over, and a firm keeps going on for 170 years. Okay? Now, the solo and small practice is a whole different story, and so the problem was recognized and addressed a few years back. The uniform standards are what Iowa adopted, so this standard is true in a lot of states besides Iowa. But basically, it governs the sale of any law practice or area of law practice, and you can see it starts at the bottom of, on the handout that I gave you, it starts at the bottom of the first page, which is page 42. It says a lawyer or law firm may sell or purchase a law practice or an area of law practice, including goodwill, if the following conditions are satisfied. Now keep in mind, it says it's either a whole practice or it can be an area of practice. So they give the example of somebody who does estate and estate planning and wills and probate, and they decide they're going to get out of estate planning because maybe they just don't want to keep up with the estate planning laws anymore, and they just want to do probate because they're getting older and their clients are getting older and they're getting a lot of probate work, and they say, you know, I'm just going to specialize in that and I'm not going to try to keep up with that other stuff, and they want to sell off that area. You can do that. So A, the seller ceases to engage in the private practice of law or in the area of practice that has been sold in the geographic area in which the practice has been conducted. Okay? So, it requires you to cease practice entirely or in the area of the practice sold in the geographic area where the practice was conducted. So theoretically, you could go to another geographic area entirely and start practicing again if you wanted to, once you sold that practice. But you have to stay out of the practice in this particular area where you sold it, unless you're keeping an area of practice, and then you can stay there, but you can't accept any business in the area of practice you sold. Now, it gives exceptions for people who sell their practice to become a judge, for example. They use that as an example, and they get down the road and they're not retained by the public on a vote. Then that's an exception. They can come back and practice again in that same area. So you have the possibility that somebody could resume practice in the area under the rules. Yes? Not clearly, no. They don't. And I didn't find anything that would give me much guidance on that in the time that I had to look for it. That's not saying there isn't something out there. But I would say that you would have to pretty clearly be outside of the commercial area, the general commercial area. So if you're an Iowa City attorney, for example, and you sold your practice and you moved over to Carroll, Iowa, for example, I think you'd clearly be outside because they're not contemplating going to another state. When you look at the commentaries under there, you could be in another part of Iowa and still be considered in another part of the another geographic area. So it doesn't contemplate that you have to move away entirely. The other thing is, there's a rule that I think I referenced it later, but there's I think it's 5.6. Lawyers are not permitted to enter into non-compete agreements. You can't do that. This is your non-compete agreement. It's don't violate the rules. That's your non-compete. So it's a built-in ethical standard or conduct standard for non-compete. Okay? And then the critical part of it, so A, you cease to practice, and then it says B, the entire practice or entire area of practice is sold to one or more lawyers or law firms, so it has to be sold to a lawyer. And then C, the seller gives written notice to each of the seller's clients. So each client gets a notice, and it talks about the proposed sale, who it's being sold to, the right to retain other counsel or take possession of their file. So they've got 90 days under the rules to decide whether they want to allow their file to stay at that office or to retain other counsel and just come and get their file. They don't even have to retain other counsel first. They can just come and get their file and then decide to retain other counsel if that's what they want to do. Okay? So under 3, it says the fact that the client's consent to the transfer of the client's files will be presumed if the client does not take any action or does not otherwise object within 90 days of the receipt of the notice. And then it says if a client cannot be given notice, you have to bring that to the attention of the court, and the court has to be satisfied that you've done your due diligence and you've tried your best to figure out how to give them notice, and then they can enter an order relating to the representation at that point. Okay? So, the other thing is kind of a critical one, is that the fees charged clients shall not be increased by reason of this sale. Now, if you read the commentaries, what I believe it's saying is that the fees being charged pursuant to the current activity or engagement that's going on with that client. So if you're charging normally a couple of $100 an hour and that client's paying $150, I think you have to keep charging them $150 for that particular engagement, but if they come back in and engage you on some other matter, you can then change your fee. That's my interpretation. Otherwise, to interpret it, you'd have to be able to say that client gets a permanent $150 fee. I don't think that's what it says at all. I think it's they have the right to expect that they're going to continue to pay the same amount until that particular engagement is done. And at a point where they could literally go and find another lawyer and make a choice to find another lawyer if they wanted to, because it's a completely different matter, for example, that would be the point at which you could renegotiate your fee arrangement and what you're doing. Okay? Does that make sense? But there is that restriction because they're trying to protect the client from being disturbed by this activity. Yes?
I assume from your comments that the client is somebody that you currently doing work for, not necessarily somebody you did accounting for last year.
Well, I would tend to, if I were buying a practice, I would send a notice to all clients, even where there's no active engagement going on. The only thing that does is where there's no active activity going on, the fee issue doesn't become quite as much of an issue, because if they come into you with a new matter, then I think you can say we have a different fee structure now. Because the practice that's sold can themselves raise their fees. They just don't generally raise their fees with clients they're already doing work for when they've quoted what their fee is going to be for that work, right? They usually wait. But does that answer your question? Your objective is to get all the clients, because it's rare for anybody to have a whole bank of clients that are all active at a given time. I don't know of anybody that really, most people have a practice where there's lots and lots of dormant clients, but they'll come back for things that come up, like buying a house or whatever it might be. Okay? So, any questions about that? So we have that restriction in mind, and that can get a little complicated. I got thinking about this. When you think about the kind of information that you can share, I think when you bring somebody in and they say, yes, I'm interested in your practice. Let's say you've shown them numbers. You've shown them your revenue numbers, and you've shown them the kind of practice you have, and how many clients you have. You've given them information that does not disclose client confidential information. There's a point at which the negotiations are going to get to the point where there has to be a conflicts check, for example, where you have to begin to share who the client is, at least. And then there'll come a point where you've got to share how the client revenues look per client and so forth, because as an evaluator of price, I want to know, one of my questions is going to be, what's the lifetime dollar value of your client? Because since clients are not active from year to year, and you're taking clients that might have value in the future, what's been their average value for the last 5 years? What's been their, we can come up with a number that will tell us something about the value of that client. Okay? So there is information that we would have to discover, but you can't disclose that, I don't think, to a buyer until you're really in the last throes of a deal, and you're giving notice, and there's going to be an impending transfer. So what's my practice worth? This is a dicey issue when it comes to a law firm, as I said. When you think about 3 basic valuation methods, the market approach, the income approach, and the asset approach, here are the challenges for a law firm. Pricing information under the market approach is not readily available for law firms, and non-law firm professional practices have substantial differences. So there's very precious little information out there to do a comparison. Because most of those deals are completely confidential, and you can't discover what they did. You don't know what they did. And there's no reporting. So when we do a deal and we take it to the closing table, we report to some national affiliations that we have so that we can all get data, right, on what was the multiple used in this kind of business, and what was the multiple used in that kind of business. Law firms have precious little information on that. Okay? So it's hard to do that, and you can find big differences if you try to compare them to accounting firms and selling, other kinds of practices. There are so many differences between them that it's just hard to do. The income approach, most attorneys remove all earnings so the calculations become more hypothetical than real. Okay? So Let me give you an example of a hypothetical. You take $150,000 a year out of your practice. Somebody that's buying the practice is buying it because they're new to the profession and they came to the conclusion that buying a practice is going to be easier than trying to build one and cheaper in the long run than trying to build one, but they're willing to take $75,000 a year or even $50,000 a year while they're trying to build their new practice. So theoretically, this practice has thrown off $100,000, isn't it? You could call that net profit. And that's what you base your evaluation assumption on, is what is it throwing off over and above what the buyer's willing to take in order to have this advantage. Because keep in mind, most buyers of law firms are not financial buyers in the sense that they're buying it for ROI or return on investment. They're strategic buyers. They're buying it to run it, to grow themselves, to grow their practice, and it's a strategy. And it might be like somebody in a neighboring county buying one in the next county over. And you know, there's a lot of ways that it could come about, but they're really strategic buyers. Strategic buyers will pay weird amounts. I mean, they will. They'll pay what they think it's worth. It's a gut check. I mean, there was an offer on the table that I learned about the other day at an M&A conference. We're typically talking about multiples on bigger deals, like $2.5 million EBITDA, which is a concept of how much net earnings there are in the company. You know, we might be looking at multiples of 8 to 10 times those earnings as a way of valuing. This is a company that was offering 30 times. There's no way that they could make money on that, but they had plans, right? I mean, it was a strategic buy. So Steve Ballmer just paid $2 billion for the Clippers. It was valued at $900 million. You get it? Well, that was more than a strategic buy. That was a Steve Ballmer likes basketball buy. That's what that was. So, asset approach. Tangible assets are minimal, and off-balance sheet intangibles, such as brand, is dubious since the reputation is more personal. It's hard to value brand in a law firm and how that brand would be able to carry over. And the intangible assets are pretty inconsequential. I mean, it's computers and desks and, you know, what have you. So, we ask the question, what's the buyer really buying? Are they buying a job? Are they buying a place to work? It's a great question, because if they're buying a job, all you have to be able to do is show that you can financially make it work and they can financially pay you, and that's a pretty good deal. It's better than a startup. It's like a client base all ready to happen. Are they buying an add-on similar to a similar practice? Are they buying a different type of practice with different expertise? These are all strategic buys. Are they expanding to other territory and or clients? Are they removing competition? Okay? So when you think about the valuation methods, I talked about multiples earlier. You begin with, in any business, and let's talk about business in general first, and then we'll talk about law firms. You begin with sales. And then from sales, you have a term called EBITDA, which stands for earnings before interest, taxes, depreciation, and amortization. So, when you go to the bottom line of a tax return, you add back depreciation, you add back any amortization figure, you add back taxes if you're on the after-tax line, and interest. Because you don't know what the buyer's financial structure is going to be. If they're paying cash, they won't have any interest. So you add back those things. It's called EBITDA. It is a very common acronym that's used in the merger and acquisition industry. And then in the smaller business world, anything below $1.5 million in net earnings, you're going to talk about a different number called SDE, or seller discretionary earnings. That adds back owner comp, salary, benefits, auto, etc., and non-recurring discretionary expenses. So you're going to add back either the seller's compensation or the portion of their compensation that you don't need as a buyer, and any perks, like the automobile owned by the law firm. You know, the buyer may say, well, I have my own car. I drive my car personally. I don't have my law firm own my car, so we're not going to own a car. right? So you add that back. Let's say you had a big settlement that had to happen, and you had to pay something, and it was $10,000 or something like that. You add that back. It's a non-recurring expense. So we look at what is the probable cash flow that if the buyer ran the firm just like you did and was able to put in the same kind of time you did and energy you did and get the revenue you did, what would they likely get? So in a law firm, these become, in a business, these become more than hypothetical numbers. They're pretty real numbers because, we can predict on a business that's been around for a few years what it's likely going to do. I mean, it has customers out there that most of whom aren't even going to know the business was sold. They're just going to keep buying stuff from the business, right? And we can track what the business performance is going to be. In a law firm, this becomes a far more hypothetical conversation, because what if the person gets in there and they don't perform the same as you do and they irritate people? Or what if, the clients decide to start an exodus of some kind? There's all kinds of things that can happen. So it really becomes a hypothetical thing for a time. So when you get the most value from your practice, if I were to go to rule of thumb research, and we have access to Pratt stats and rule of thumb reports that tell us whatever you do know out there about law firms, what is it? Well, we find that we've seen sales anywhere from 1 to 3.5 times EBITDA, or 0.5 to 2.5 times SDE. When you add owner comp and all those perks back in, it gets to be a bigger number, so the multiple drops. So it almost turns out to be 6 of one and half a dozen of the other. It's about the same amount. That one multiple of EBITDA versus another multiple of SDE gets to be a pretty close to the same number. Or under rules of thumb, 75% to 125% of annual revenue. That's an easier way to figure it. You can say, I could probably get 75 to 125% of the revenue that I got, over the last 3 to 5 years. Average. You average it out.
That's gross.
Gross revenue. Right. So it's finding that number that, somebody would say on a financed basis, what they would be willing to pay and be able to pay back in a reasonable period of time, 3 to 5 years. What multiple is going to depend on a lot of things. It's going to depend on, on the low side, the multiple, if there are low entry barriers. Let's say that you are an older attorney and your revenue has been declining for the last 5 years and your clients have been migrating. And there's plenty of room in the town you practice in for another lawyer. The marketplace, gives plenty of room for it. So one of my conversations in my head as a buyer is going to be, is there a low entry barrier here? Can I just go open an office and just start picking them off? Why should I pay for it? Right? So that's one question. That's an analysis we always do in the business. What's the entry barrier? If the entry barrier is kind of high, if you've got a lot of licensing to get and you've got to get a franchise agreement and you got to, it's like, what the entry barrier for McDonald's is quite high, isn't it? Okay? Old assets, high client retention volatility. Like I said, they're migrating, they're moving, so it's losing clients. Declining sales and profits, people dependent, high staff turnover, and we call it doing it, meaning that it's a job. Somebody's got a job and they're working it, and what you're really selling is you're giving somebody else the right to come in and do everything you're doing 80 hours a week. Right? How much are they going to pay for it? So the opposite, growing revenues and profits, stable client base. And this is an analysis that has to be done. I'm going to go through this again in a couple of other slides, but you really have to look at client base and see what it's doing. It's differentiated. There's a brand. It's well known. I mentioned Carl in Watchier. He was the only lawyer in Watchier, and he was beloved. Okay, he's a brand. Carl was a brand. Nobody would leave him if they didn't have to. That was the truth of it. Yeah.
What if you're personal injury lawyer and you represent the person resolve the personal injury claim and you tend to not sue the
Well, and that's a great question. I think you really have to look at it as an income flow and say, on an average basis over a certain period of time, pick 5 years, pick 3 years, what does your personal injury practice attract in terms of businesses, and what are you able to produce? So we had a coach client, for example, who was a personal injury plaintiff's lawyer. He set up a series of systems that was literally a machine. I mean, people would come in and they would be interviewed, and there would be an investigation, and there would be discovery done, and there would be witnesses interviewed, and he didn't do all of it. I mean, he had a lot of people doing a lot of different things, and 90% of everything that came through that door settled, and 10% was tried. And then he had this whole other side of the business that got it ready for trial, okay? We could pretty well predict over a 5-year period what that business was going to do from year to year. You could look at the flow. They weren't the same clients and the same people. So your 90-day notice is going to go to the active stuff, right? Definitely the active stuff. That's what you're wanting to make sure that you hang on to, or any inquiries that haven't turned into a claim yet. All of those people. The ones that are all done, not necessarily. That's a different kind of practice that you're describing. But a well-orchestrated practice is not a practice by accident. It's pretty well orchestrated. And that's what you're looking for. And the more well orchestrated it is, and the more you can predict, the more money I'm going to pay. Quite simply. I mean, you've seen ads, Hupy and Abraham. I don't know what their numbers are. I have no idea, but it's on television, right? So they obviously attract some clients because of those ads. I don't know. But they use William Shatner. So they must pay him something, right? So yeah, and there are so many variations on the doing the statistics of it and the mathematics of it. You're always going to have to make some assumptions when it comes to a law practice, though, because there's so much artifice in trying to create that, and it all comes down to a negotiation. What's the buyer willing to pay, and what's the seller willing to sell for? That's the end of the story. Fresh assets help. Key people and longevity helps. Turnkey systems, well coached. That's a shameless pitch, and essentially those kinds of things drive the differentiators in value. Deal structure can drive it. Not so often in the law. Most law practices are not structured as pure corporate entities that retain profits and so on. They usually are all pass-through entities, mostly LLCs or PLCs and so forth. So when you get into deal structure, that doesn't matter quite as much. Seller due diligence. This is really important. What are the purchasing lawyer's or firm's credentials, experience, and expertise? You have an ethical responsibility under the professional rules of conduct to make sure, not sure, I should say, that to as nearly as possible, ensure that the clients are going to be properly represented by somebody that's competent in the areas that you practice. So you can't just bring somebody in and throw your hands up and say, well, whatever they do, right? It's their problem. They're buying the practice. So you owe it to your clients to interview them for their expertise or their experience. What's the purchasing lawyer's reputation? I mean, obviously, you want to make sure that they retain the clients, because later I'm going to talk about deal structure and I'm going to talk about earnouts. One of the common things is not to pay you everything up front. Let's see what actually happens, and then I'll pay you the rest. Right? It's an earnout. Is there a cultural and philosophical fit with the clients? Are these the kind of is this the kind of attorney and the kind of personality that my clients would mesh with or meld with? Is that right? You want to walk away feeling like your clients are going to say good things about what you did for them when you left. You left gracefully and you left them in good hands. That's what you want to feel like. Is the purchasing lawyer financially sound? Well, you kind of make assumptions they might be, but you'd be surprised, right? Are there any conflicts of interest that would result from the purchase? So how many conflicts are there? There's a conflicts check that will happen in the course of the acquisition strategy. But you got to see if those conflicts are major, that's going to impact the price. No question about it. and the availability of tail insurance coverage. You need to check to see if you can get some malpractice coverage, tail insurance, to cover you for anything that might happen after the sale that you get blamed for. Buyer due diligence, they're going to want to see 3 to 5 years filed federal income tax returns. They're going to want to see filed business and payroll tax returns, salaries, bonuses, benefits, employee reviews, asset, proof of ownership, titles, loan and lease agreements for debts, leases, equipment, subscription services, library services. Man, you can't believe all the stuff that you've accumulated, right? All the agreements that you have and all of this stuff. So they need to see them. We have a manual that we've created that our general manager of that section calls Seller Confidential, and it's a seller checklist of, here, now that you're going to be a seller and you're going to list, these are all the things you need to start getting together, you know, and putting together in terms of due diligence, right? Malpractice insurance policies and applications. Not just the policies, but the applications. What did you represent on the application? That makes a big difference, because if you misrepresented something, that's a problem. Okay? General liability and workers' compensation policies and applications. Accounts receivable and payroll reports. Conflicts check. Client lists and fee lists for at least 3 years. That comes later in the conversation, but they're going to want to see at a certain point on a confidential basis with a signed, not only a confidentiality agreement, but I would highly recommend a non-solicitation, non-circumvention type agreement where they won't go out and solicit because they've seen the list. Most of them are going to know what your clients are anyway, it's depending on the size of the town and you know, that type of thing. Review of practice management policies and procedures, file opening procedures, calendaring, tickler systems, billing systems, conflicts check systems, case management, and so on. And review of open matters and deadlines. Obviously, when somebody takes it over, they're getting whatever you did, and they got to live with it, and they got to meet the deadlines. They've got to do all the things that got to complete the things that you were supposed to do. You know, you sell a case in the middle of an appeal process, for example, there's a brief deadline and all of that. So you think about deal structure in common terms. Like I said, asset sale versus stock sale doesn't happen so often. Earnout arrangements are common in law firm sales and similar sales. Where there's any doubt about the efficacy of the ongoing earnings and the fact that they're going to come back and repeat themselves, usually the buyer is going to propose some kind of an earnout where maybe you'll get 50% of the deal at closing and the other 50% when certain targets are met and hit. And certainly they're going to want to wait out the 90 days to see who pulls the file, you know. And that's why what happens in the evaluation process is you really have to try to figure out how you're going to determine a per client value. In other words, you're going to, you know the formula you use to figure out the overall value of the firm. Then you got to figure out how is one client's file being pulled going to impact that value. And that's going to be based on the lifetime dollar value of that client, like I said. Like what if they come in every 5 years and have you read an abstract versus somebody that's got ongoing business questions that they're constantly coming in and you're doing an annual meeting with their corporation and on and on and on. Okay? Financing. Like I said, a lot of this stuff is seller financed, but banks will loan money on deals like this. They will loan money on law firm acquisitions. SBA loans are available for it. If you're not familiar with how SBA loans work, they basically guarantee or insure 75% of what the bank loans you, and they are in the goodwill business. In other words, they loan money where nobody else will, or they insure money where nobody else will, because it's mostly goodwill. Tax implications change depending on the organizational structure and allocation of assets. Some of you either know or should know that Goodwill, for example, is an asset that is written off over 15 years. I think it's under Section 197. So you actually get to write off Goodwill. But there are other assets that would be written off over a short period of time. So it's kind of important to look at how you're going to allocate the assets. Leasehold improvements, desks, furniture, and all this kind of stuff, okay? Computers. Non-compete covenants, as I said, are prohibited. And reps and warranties really become very, very important, as you can imagine. You can just think of the myriad of representations and warranties you'd want to get if you were a buyer of a law firm, to make sure that they're disclosing everything they can possibly disclose to you so that you're not blindsided by something in the future. And so the reps and warranties can become fairly extensive in a law firm sale agreement. Finally, doing your homework. Timing, I got 5 minutes. That's pretty good, huh? It's okay. I suggest to people, if you're thinking about trying to transition your practice or sell your practice, spend some time working on it, not just in it. Spend some time trying to dress it, to really make it look like it should for sale. There's a lot of value in that. There's a tremendous value in that. Processes and people are your most valuable assets. The most valuable things that you can create today are very solid processes and development of people, making them masters of those processes so that you can tout having a very turnkey set of systems and standards that, part of what you're selling is that way of doing business. The reason why Raining Rose got 4 full-price offers, they had a manual in every department that described everything that happened in that business. And the buyers who bought it came from McLeod. They had lots and lots of money. They said, this business literally runs itself. All we have to do is figure out how to grow it. That's why they made a full-price offer. And the other comment they made was, this business has 1 customer service rep and a manual telling them how to do it. We have 200 and no manual. And our response was, well, McLeod, it's, telephone companies. Of course. No wonder, right? Prepare your clients to stay with your firm. Talk to them. Talk to them about transition. Talk to them about your future. Talk to them about, your life and what you may need to think about doing and so on, and that you're going to make sure that they're taken care of if that's what you plan on doing. Obviously you have to use your discretion on how you do that. You don't want your clients flooding out the door. But at the same time, they're wondering, what's going to happen if he just decides to keel over or, God decides to take him or her. Continue to grow your client base. Run your practice like you're going to keep it. Until the day you actually get out of it, run it like you're going to keep it. Don't let it run downhill. And understand the effect of decisions you make on cash flow and value. So your homework includes, making sure that your business records are current, making sure that you know your client base, that you know your business, your market opportunities, and your financial model. In other words, how does your business work? Is it profitable? Can you show consistent profitability in it? And how are you differentiated? That begins with the story that I started with this morning at the very beginning. What differentiates you, and how do you begin that conversation? Questions?